Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about entrapment. No, it's not what you think. I'll have more on that in just a moment. Many people think that entrapment is when the government sets up a situation where someone can commit a crime. And then when the person commits that crime, they can cry entrapment. And that's not the situation. So let's look at what entrapment really is. We'll do a little bit of case study here, and then we'll go through a couple of other scenarios. So let's start with what entrapment is. Entrapment is when the government overcomes a person's predisposition to behave lawfully and instead encourages, entices, and more or less bullies or manipulates them into committing a crime. It is what's called an affirmative defense, which means that because it's an affirmative defense, the defendant has the burden of proving that they were entrapped. But there's a good distinction here, and that is, while the government must prove its case beyond a reasonable doubt, the only thing that the defendant has to prove is more likely than not. So the standard of proof on an affirmative defense in a criminal case is lower than the standard of proof for the government in the same case. So the last time the United States Supreme Court weighed in on the subject of entrapment was in 1992 in Jacobson versus the United States. You may not be aware of the fact that prior to 1984, you could send and receive pictures that you shouldn't be looking at through the mails. There was no federal prohibition on that. But they passed a statute in 1984 that made it illegal. So this is from the syllabus of the case. At a time when federal law permitted such conduct, Petitioner Jacobson ordered and received from a bookstore 2 magazines containing photographs that he shouldn't have been looking at. Subsequently, the Child Protection Act of 1984 made illegal the receipt through the mails of things you shouldn't be looking at. After finding Jacobson's name on the bookstore mailing list, 2 government agencies sent mail to him through 5 fictitious organizations and a bogus pen pal to explore his willingness to break the law. Many of those organizations represented that they were founded to protect and promote freedom and freedom of choice, and they promoted lobbying efforts through catalog sales. Some mailings raised the specter of censorship. Jacobson responded to some of the correspondence. After 2.5 years on the government mailing list, Jacobson was solicited to order things he shouldn't be looking at. He answered a letter that described concern about these kinds of images as hysterical nonsense and decried international censorship, and then received a catalog and ordered a magazine depicting things he shouldn't have been looking at. He was arrested after his controlled delivery of a photocopy of the magazine, but a search of his house revealed no materials other than those sent by the government and the images that were in there. At his jury trial, he pleaded entrapment and testified that he had been curious and that he had been shocked by the magazines because he had not expected the magazines to show what they showed. He was convicted. The Court of Appeals affirmed. Held, the prosecution failed as a matter of law to adduce evidence to support the jury verdict that Jacobson was predisposed, independent of the government's acts and beyond a reasonable doubt, to violate the law by receiving those pictures he shouldn't have been looking at through the mails. In their zeal to enforce the law, government agents may not originate a criminal design, implant in an innocent person's mind the disposition to commit a criminal act, and then induce commission of that crime so that the government may prosecute. Jacobson was not simply offered the opportunity to buy these images, after which he promptly availed himself of that opportunity. He was a target of 26 months of repeated government mailings and communications. I guess you have to give the postal inspectors credit for being persistent. The government has failed to carry its burden of proving predisposition independent of its attention. The pre-investigation evidence, the two magazines, merely indicates a generic inclination to act within a broad range, not all of which is criminal. Furthermore, Jacobson was acting within the law when he received those magazines, and he testified that he did not know that the magazines he ordered would depict things he shouldn't be looking at. As for the evidence gathered during the investigation, Jacobson's responses to many communications prior to the criminal act were at most indicative of certain personal inclinations that would not support the inference that Jacobson was predisposed to violate the act. On the other hand, the strong, arguable inference is that by waving the banner of individual rights and disparaging the legitimacy of constitutionality of efforts to restrict the availability of these kinds of materials, the government not only excited Jacobson's interest in material banned by law, but also exerted substantial pressure on him to obtain and read such material as part of the fight against censorship and the infringement of individual rights. Thus, rational jurors could not find beyond a reasonable doubt that Jacobson possessed the requisite predisposition before the government's investigation and that it existed independent of the government's many and varied approaches to him, reversed. Now again, it may not be obvious, but just because the Supreme Court, interpreting federal law, applied that entrapment defense in that case, that does not mean that that same defense is available in the states, in a state prosecution for a state crime. And many states have different rules about that. And we're going to look at a case now that involves exactly that situation where you have someone who is essentially entrapped by a government agent. This case comes to us from the Supreme Court of North Carolina. It is State versus David Allen Keller. Appeal pursuant to the statute there from the decision of a divided panel of the Court of Appeals, affirming a judgment entered in 2016 by the Superior Court in Lincoln County, heard in the Supreme Court on 9 March 2020. In this case, we consider whether the trial court erred by refusing to instruct the jury on the defense of entrapment. Defendant contends he presented sufficient evidence of entrapment to allow the jury to decide the factual issue of whether he was entrapped. We agree. For the reasons stated below, we hold that the trial court committed prejudicial error by failing to instruct the jury on the defense of entrapment, and we reverse the decision of the Court of Appeals. Before we go too much further, I want to point out here that we're talking about a situation where if I said that this was sort of like what happens in Chris Hansen's Dateline series where he has to catch a predator, you would understand what kind of investigation we're talking about here. There are numerous redactions in this, and I did that to comply with YouTube's policies. So, on 11 May 2015, Detective Brent Heavner worked as an undercover officer in the operation targeting online criminals for the Lincolnton Police Department. He began posting online as Kelly, and Detective Heavner posted a personal advertisement on the personal encounters section of Craigslist. Now, we don't need to read the entire ad. We just need to realize that he was essentially going out there to solicit a certain kind of individual who might be interested in engaging in unlawful conduct with him. And so that's what he did. So the defendant responded to the post and asked him what his number was and that sort of thing. So now we're going to jump down to the situation where I'm going to paraphrase what happened. So the interesting part of this is that when the detective was communicating with this individual, he indicated that he wanted to engage in certain conduct that would be unlawful if his age was of an age that he asserted that it was. And when he told the defendant that he was not 18 years old, The defendant said, well, that means we can't do the unlawful things that you're suggesting. And in spite of this, he basically told the detective basically told the defendant, if you don't agree to do this with me, I'll go find somebody else who will, because I'm thinking about running away from home. So ostensibly to protect this young man from the online predators that he knew were out there, he said that he would agree to meet and that they could talk about things. The detective in that situation was blunt and essentially put his own uh, safety at issue. And this guy told him, look, you don't want to do that. It's not good for you. You could wind up with bad people. And he basically made the assertion in his texts with this detective that he wanted to protect him. Well, they met up and he was arrested and he was charged with a criminal act. So his housemate testified on behalf of the defense, and he testified that he'd known this guy for 25 years and he currently resided with him, and that every person he had ever brought home to his house had been above the age of 18. And then the detective testified that he had to confirm on Craigslist that he was over 18 years old. And the defendant also testified and said he used Craigslist because Craigslist said you had to confirm that you were over 18 and you had to provide a birth date before you were allowed to post in those encounter sections. So he stated over the course of 10 years he'd met multiple men on that website, and some of them had lived with him for extended periods of time. The long and short of it was that he did not look to engage in conduct that would be unlawful, but the detective more or less insisted that he agree to do that. The issue before the court is whether the trial court committed prejudicial error by failing to instruct on entrapment. The resolution requires the court to determine whether the defendant was entitled to the instructions, whether those instructions were impermissibly inconsistent with the defendant's other theories of the defense, and whether the defendant was prejudiced by the trial court's failure to give the instructions. So there are some really great quotations in here. The first duties of the officers of the law are to prevent, not to punish crime. It is not their duty to incite to and create crime for the sole purpose of prosecuting and punishing it. The defense of entrapment is available where there are acts of persuasion, trickery, or fraud carried out by law enforcement officers or their agents to induce a defendant to commit a crime when the criminal intent lies with the law enforcement agency and obviously not the defendant. And entrapment is a complete defense to the defense charged. So the crucial inquiry by this court is whether law enforcement or the defendant created the criminal intent. If the defendant has a predisposition, the origin of the criminal intent lies with the defendant, and the defense of entrapment is unavailable. Predisposition may be shown by a defendant's ready compliance, acquiescence in, or willingness to cooperate in the criminal plan, where the police merely afford the defendant an opportunity to commit the crime. Generally, the issue of whether a defendant is entrapped is a question of fact to be resolved by the jury. And they say the evidence here, viewed in light most favorable to the defendant and assuming the truth of his testimony, is sufficient to allow a reasonable juror to conclude the defendant was not predisposed to commit the crime and the criminal intent was placed in defendant's mind by Detective Heavner. And that's really all we need to look at in this case. Now, this creates a bit of a conundrum for people like me who are very much in favor of civil liberties and believe strongly that the government should not entrap people, but also recognize that there are people out there who prey on certain people and that it would be good to dissuade them from doing that. If you would probably find it very interesting to go and look at the Polk Sheriff. They have a page on YouTube and they frequently post the results of their online sting investigations, and you would be amazed at the number of people that they turn up in these sorts of investigations. So while part of me says, yes, you should not entrap people, the other part of me says, well, As long as you don't induce them to do this, as long as the criminal intent remains with them and not with law enforcement, it's better to have a situation where you are preventing people from being exploited as opposed to dealing with the exploitation after the emotional and physical damage has already been done. So that's sort of where entrapment lies. But let's take a look at a couple of little vignettes here and see if we can deduce whether there's actual entrapment going on.
Yo, Mikey, it's me, Tony Two Toes. Yeah, I was talking to my brother Luigi, and he was telling me that, according to his friend who works in the alarm company, that they've disabled the alarm in that bank at First Street and 2nd Avenue. And apparently they got a lot of dough there for payroll that's coming up. I'm just telling you, you might want to know that.
Well, was that entrapment? Not at all. Tony Two Toes in that situation just set up the opportunity for his buddy to go knock over the bank. He didn't tell him to go do it. He didn't urge him to go do it. He simply said, hey, there's this piece of fruit out there. It's boxed fruit ready for you to take. It's not entrapment. And if you are dumb enough to take that kind of invitation to go rob a bank, you deserve everything bad that happens to you. Now let's take a look at the second vignette.
Hey, yeah. Look, Mikey, I talked to you just the other day, and I told you about that bank at First Avenue. What's wrong with you? You ain't knocked it over yet? Well, come on, man. What are you waiting on? Look, either you knock it over or I'm going to give this to somebody else. And I'm going to tell your boss that you blew a perfect opportunity to score something for the group. That's okay. You're just going to have to deal with it. Either you do this or I'm getting somebody else to do it. I'm tired of waiting on you.
You see the difference here? Now he's pressuring him. Now he's saying, you got to do this or I'm going to get you in trouble with the boss. It's a subtle kind of pressure, and there probably already is a bit of predisposition there to commit this crime, but now the government agent is going a step too far. He's basically threatening him if he doesn't carry forward with the act. So that's sort of the big distinction between true entrapment and what people think is entrapment. The government can set up an opportunity for you. They can say, hey, look, there's no alarm in that bank. There's nobody who's going to be aware if you sneak into the pharmacy and pick up, 10,000 opioids. All of those things are opportunities to commit the crime, but the criminal intent, the intent to actually do the crime, remains with the person who does the crime. It is where the government plants into the mind of the criminal the desire to do it and essentially exploits them into doing that act where you really cross the line. This is a very technical area of the law. It's a technical area of the criminal law. I am not a criminal attorney. This is based on my reading of the cases. If you had a situation where you were facing a criminal charge and you believe you were entrapped, you need to talk with an attorney and find out whether or not it is true entrapment or not. And again, it may or may not be a defense that is available in all states if it's a state crime, but of course, because the Supreme Court has spoken on it, it would be a defense in a federal crime. Well, that's what I have for you today. Thank you so much for watching. If you have the opportunity today, go out of your way and do something kind for someone. It will indeed make your day a better day. Thanks for watching. Catch me on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.